Every time California touches the subject of firearms, it seems to spark another round of legal battles, political maneuvers, and confusion among the public. The latest controversy centers on AB 1078, a bill that has moved through the legislature and is designed to replace the old one-gun-a-month law that the Ninth Circuit Court of Appeals struck down in Nguyen v. Bonta. For anyone following the long struggle between the state government and the courts, this development feels less like a compromise and more like an attempt to work around the court's ruling while still restricting people in the exact same way. The context here is critical. For decades, California has been known for some of the strictest gun control laws in the nation, often becoming a testbed for regulations that other states later try to copy. Among those laws was the 1 in 30 rule, which limited purchases of handguns, and later certain long guns, to only one every 30 days. The justification offered by lawmakers was that rationing purchases would reduce trafficking, straw buying, firearm, and stockpiling. In theory, it sounded like a public safety measure, but critics argued that it punished law-abiding citizens without stopping criminals who already ignored background checks and other regulations. That debate reached a turning point in Nguyen v. Bonta. The plaintiffs challenged the constitutionality of California's one-gun-a-month policy, claiming it violated the Second Amendment. The Ninth Circuit agreed, and in a striking opinion emphasized that the government cannot dictate arbitrary time limits on the exercise of a constitutional right. The court's reasoning was rooted in the Supreme Court's more recent guidance in cases like Nguyen, where justices made clear that firearm regulations must be consistent with the nation's historical tradition of firearm regulation. There is no historical tradition of rationing firearm purchases by the calendar month, and the Ninth Circuit concluded that California's approach failed that test. That ruling effectively erased the old one-gun-a-month law. In practical terms, it meant that Californians were no longer limited to a single firearm purchase every 30 days. People who passed background checks could legally acquire multiple firearms without arbitrary restrictions. For supporters of the Second Amendment, this was a long-awaited victory, a recognition that the state had gone too far in limiting what should be a protected right. For state lawmakers, however, it was a major setback, and AB 1078 quickly emerged as their answer. Instead of acknowledging the court's decision and stepping back, the legislature pressed forward with a new framework. AB 1078 is essentially a rebranding of the rationing concept, changing the cap from 1 firearm per month to 3. On the surface, it looks like a concession, as if the state is loosening restrictions. But anyone who understands the legal context recognizes that it is a step backward, because without the old law, there is currently no numeric restriction at all. What the bill really does is reimpose limits, shifting from unlimited lawful purchases to a maximum of 3 every 30 days. This is where the frustration begins to show. The Ninth Circuit was clear that rationing rights is unconstitutional, yet California has chosen to ignore that spirit and create another version of the same law. It feels like the legislature is daring the courts to strike it down again, gambling taxpayer money and legal resources in the process. The way the language of the bill was drafted also reveals the mindset behind it. It explicitly included provisions that would have kept the limit at 1 if the state somehow won on appeal. Once the appeal was lost, lawmakers simply stripped that language and set the limit at 3 instead, ensuring that no matter what happened in court, the public would still face restrictions. When looking at the broader picture, it becomes clear that this is not just about numbers or technicalities. It is about whether elected officials respect judicial rulings and constitutional principles. California's approach signals that the state is determined to preserve control over firearm purchases regardless of what the courts say. This attitude has shaped decades of legislation, and AB 1078 is simply the latest example of a state government that does not want to let go of power once it has been claimed. The path that AB 1078 traveled through the legislature shows just how determined lawmakers are to keep this policy alive. The bill began in committees, moved quickly despite strong opposition, and passed the Assembly with little resistance. It cleared Senate committees, including Appropriations with a 5-2 vote, and advanced to the Senate floor before reaching the governor. The entire process reflected a coordinated effort to preserve restrictions even after the Ninth Circuit struck down the older law in Nguyen v. Bonta. A striking feature of the bill is the chosen effective date. AB 1078 is set to take effect on April 1, 2026. This delay might appear routine, giving agencies time to update systems and enforcement. Critics, however, argue that the gap is strategic, forcing opponents to spend years in litigation while the state prepares to entrench the law. It keeps the fight alive, draining resources from those who challenge it. The text of the bill has been especially controversial. It claims that the number of firearms allowed per 30 days is being increased from 1 to 3. That phrasing is misleading because the Ninth Circuit ruling removed all limits. Right now, Californians can legally purchase more than one firearm within 30 days. Framing the change as an expansion gives the illusion of greater freedom when the bill actually reduces lawful access from unlimited down to 3. It feels like wordplay meant to soften public reaction. This kind of wording is not accidental. It reflects a philosophy that constitutional rights can be rationed. Legal scholars sometimes describe it as treating rights like privileges, given in measured amounts rather than recognized as inherent. The Constitution, however, does not authorize states to ration rights, and courts have repeatedly emphasized that the Second Amendment is not to be relegated to second-class status. By presenting restrictions as if they were gifts, lawmakers attempt to normalize government control over individual rights. The Bruin decision from the Supreme Court in 2022 set a clear standard for firearm regulations. Any restriction must be consistent with the nation's historical tradition. There is no tradition in American history of limiting purchases by the calendar month, no record of colonial or early American laws imposing numerical caps. This is why the Ninth Circuit ruled against the one-gun-a-month law, and it is the same reason experts expect AB 1078 to fall. The bill's defenders insist it is a sensible compromise, but compromise has no place if it conflicts with constitutional guarantees. Beyond theory, enforcement raises practical concerns. To impose a 3-per-month rule, the state must monitor every transaction, build databases, and ensure that buyers do not cross the line. This adds bureaucracy, costs, and errors. A law written to stop trafficking will almost certainly burden ordinary citizens instead, while traffickers who already operate outside legal channels continue unaffected. The mismatch between intention and impact is a theme that repeats again and again in California's approach to gun laws. Supporters argue that limiting bulk purchases addresses trafficking risks. They often cite studies claiming links between mass acquisitions and illegal resale. Yet, those studies are limited and have not convinced courts. Even if the intent is sincere, intent cannot override constitutional limits. That is why opponents see AB 1078 not as progress, but as a defiance of the courts and a direct challenge to the principles affirmed in Nguyen v. Bonta. The stage is already being set for lawsuits. Advocacy groups have made clear they will fight, and California knows it. Despite this certainty, lawmakers have chosen confrontation, signaling that political agendas matter more to them than respecting judicial rulings. The practical consequences of AB 1078 are already being discussed by gun owners across California. People who follow the law, who pass background checks and comply with every regulation, are the ones who will feel the squeeze. For them, this new cap means being told by the government how often they can exercise a right that is supposed to be constitutionally protected. Families who may want to buy multiple firearms for personal defense, or collectors who seek to add to their collections will suddenly be placed on a government ration schedule. Nothing about this addresses criminal activity, yet everything about it impacts lawful citizens. Communities that value the Second Amendment see this as a deliberate move to discourage gun ownership altogether. By making the process slower, more complicated, and limited, the state effectively tells residents that their rights are conditional. That message matters because it normalizes the idea that the government can rewrite constitutional boundaries whenever it chooses. If a right can be rationed to 3, what stops lawmakers from lowering it again to 1? Or even none? Once the principle is conceded, the actual number becomes just a matter of politics. Legal experts and advocacy organizations are already preparing the next round of lawsuits. The expectation is straightforward. AB 1078 will be challenged under the same logic that brought down the one-gun-a-month law. The Supreme Court's Bruin framework does not leave much room for rationing rights based on the calendar. Courts will ask for historical examples, and the state will not be able to produce them. Just as Nguyen v. Bonta confirmed, these types of arbitrary limits do not fit within American legal tradition. The likely outcome is that California will face yet another defeat in federal court. Despite this predictable result, California has a history of enforcing contested laws for as long as possible. Even when courts eventually strike them down, years may pass before rulings are final. During that time, residents live under restrictions that may later be declared unconstitutional. This pattern has repeated with magazine bans, assault weapon definitions, and other high-profile regulations. AB 1078 appears set to follow the same cycle: pass the law, enforce it, face lawsuits, lose in court, but only after years of disruption. The frustration many people feel is not only about the specific law, but about the disregard for constitutional checks and balances. When courts rule, lawmakers are supposed to respect those rulings. Instead, the state treats court decisions as obstacles to maneuver around. This erodes trust in the system and deepens the divide between government and the governed. California's insistence on pushing laws that are likely to fail in court suggests that political symbolism matters more than legal durability. The state leadership wants to show that it is tough on guns, even if that toughness collapses in federal court. For ordinary people, this means constant uncertainty. They never know if the laws in effect today will still be valid tomorrow. They live in a cycle of confusion, where rights are granted, restricted, then restored, only to be restricted again. This instability makes it difficult for residents to plan, to feel secure, or to trust that their government operates in good faith. The endless loop of regulation and litigation has become exhausting, yet California shows no sign of breaking the pattern. Looking ahead, it is almost certain that multiple lawsuits will be filed before AB 1078's effective date in 2026. Gun rights organizations are already signaling that they will take the fight back to federal court. They believe, with strong precedent on their side, that the law cannot stand. Until then, Californians will continue to watch their legislature prioritize control over constitutionality. In the end, AB 1078 is more than just a bill about numbers. It represents a struggle over whether constitutional rights are treated as permanent guarantees or temporary privileges granted by politicians. The fight is not simply about 3 guns in 30 days. It is about whether a state government respects the boundaries set by the Constitution and the rulings of federal courts. Californians have seen this story before, and they know how it is likely to end. But until the courts speak again, they remain stuck under the weight of another law that values political theater over fundamental freedom.